And I think this is the question that maybe the department doesn't understand. If we say that, if you can go back to Article Section 5 in the beginning, it says a person ceases to be a member of the board when that person is no longer eligible, resigns, absent, has completed his or her term, is removed from office in terms of subsection 7, or the member accepts political office. Now, political office is not included in subsection 7. And then that's my question. If somebody, say, for example, is on the board, the one exclusion is to say that it mustn't have any political office. But as soon as he becomes a member and he joins a party and accepts a political office,
and gets nominated,
does that mean he now stays within the board, but is also in a senior structure or a decision-making structure of a political party? And I think that was why that proposal was there in the first place, is to say that we must differ between government structures and political party structures, and for a board member, he mustn't be in either one of the two.
They have understood the question now. Can we, after thinking it through, because it says you are talking about all these government structures, you're no longer talking about this political office bearers. What happens if somebody gets elected into whilst he's a member of the board? Is it something that you can think now, or you would want to come back to it?
Chair, I don't see any harm in us accepting the particular suggestion, Chair. Okay. It will then just mean that we will read reference to the phrase political office within the context of the definition under section number 1. Unless my colleagues, thank you. Thanks, Chair.
Let's move then.
Thank you, Chair. Chair, the next particular comment, Chair, came in relation to section number 12, between brackets 1. I think it was a new E that suggested that the minister must gazette the names of the members of the board as soon as it is practical. The comment from the department is that the comment is rejected because this particular requirement is already addressed in section number 10 between brackets 10 between brackets 7 above, Chairperson, where it says that when the president appoints the members to the board, that must be gazetted. And it's in that context where we believe that the suggestion is already addressed in 10.7. Thanks, Chair.
Thanks. We can move if there's no hand.
Thank you, Chair. The next comment was in relation to section number 16, with regard to the board members. What you will see, Chair, is that the way the section has been crafted, Chairperson, it was very specific around what committees the board can establish. And the comment that came through last week in the session was largely around why the limitation. Why can't we consider making it a bit more broader? And the comment from the department, Chairperson, is that the limitation is not, or in fact, the limitation was driven by the cost factor, although the board is still at liberty to establish additional committees should a need arise. We should not constrain the board to run its own affairs. In other words, that particular, what we see on the text here, Chairperson, in the bill, 16.1 A and B, is not a closed list, and the board is still at liberty through their own structures to establish additional committees should a need arise. Thanks, Chair.
Thanks. Any comment or nothing? Then we move. Oh, I see Honorable Smiley.
Chairperson, would there be when you are in the process of establishing new new boards or new committees of my apologies for the wording, would there be a need then to gazette or to gazette the functions of that new committee, or to say what they should be doing? I'm just asking in the process of going forward, not to having committees for the sake of having committees.
Any quick response, Mr. Naidu?
Thank you very much, Honorable Chairperson, and to the member for the question. I think largely the terms of reference which committees in the board operate within are developed by the board itself. It is tabled through the board and ratified, endorsed there. And in my view, Chair, ever since the inception of the board, that is how things were done, and it worked quite well in terms of them determining their own internal processes and procedures. But to get a real, on the field experience as to what happens currently, perhaps, the CEO of the board who's here may also want to input should the response not be adequate. Thank you, Chair.
Thank you. With that, can we move then?
Thank you, Chair. So the next comment, Chairperson, is in relation to section number 16.4. 16.4, Chairperson, where there was a proposal that we add additional text to the subsection. So the section will now read: when appointing members to a committee, the board is not restricted to members of the board, but at least one member of the committee must be a member of the board. In section 9.2 above apply equally to the appointment of board members. And a comment from our side, Chairperson, is that we support the input as provided, and a redraft is proposed.
Okay, let's move to the next.
Thank you, Chair. The next proposal was same section, 16.5. It was a proposal that the minister must gazette the names of the members of a committee, and the matters referred to under subsection 1 as soon as is practicable. The response, Chairperson, from our side as a department is that we don't support the suggestion. A provision is made for the board to consist of other members. It should, however, be noted that the involvement of other members has a defined period, and hence we don't see the need for the publication of their names in the government gazette. Thank you, Chair.
Thank you.
Chairperson.
Yes.
Chairperson, the department then just can explain, I mean, this is an open or can I say independent body, but it must also be open to the public. How will the public know who the members of that political or that different committees is? If it's not gazetted, if you just can answer that and give me clarity, I would appreciate that.
Okay, I see the hand of Mr. Naidu.
Thank you very much, Chair, and to the member for the question. So, to a large extent, the committees of the board consist of members of the board. So therefore, to a large extent, and maybe on an ad hoc basis or on a very rare occasion, persons from outside the board would be co-opted to be part of a committee. So based on that, Chair, we felt that the need for gazetting of these committees, the members thereof, is not necessary. And because also the lifespan of a committee could be a week, could be 2 weeks, it could be a month. And to gazette that members for that period of time we felt was not necessary. Thank you.
Thank you. Can I assume that explanation is clarifying us?
Chairperson.
Yes, Honorable Groenewald.
Thank you, Chair, and I think Mr. Naidoo explained it well. The problem I still have is there's no way for us as public to find out who is there, what is the remuneration, and so forth. Can't we then make a provision to say that it must be, published on their website, for example, or something like that, so that the public just know what is the remuneration, who is the board members, if there's other board members coming into the committees, who they are, and so forth. I think that the importance of this was more so that the public know who is the members of the board and what they're being paid. Thank you, Chair.
Thank you.
Chairperson.
Okay.
Chairperson,
Yeah.
can you hear? Can you hear me?
Yes, I can.
Okay, I support Honorable Groenewald and respect to Mr. Naidoo, which I respect, is that the lifespan of the committee, as much as it can be a week, we have seen that it can also be months or years due to the committee not achieving or completing their duties. So let us not assume it will be a short lifespan. Let's make sure that the public knows, because that's our vision as Parliament, to make sure that we involve the public in all processes. So the suggestion made now from Honorable Groenewald, I will support. Thank you, Chair.
I hope we understand each other. I think when Mr. Naidoo, can I allow you again to come in?
Thank you very much, Honorable Chair. I think it is a proposal that we will consider positively, so we will take it to our drafters as we revise the bill after the engagement today. Thank you very much.
Thank you. Let's move then.
Thank you, Chair. The next particular suggestion, Chair, is on section number 18, which is titled The Conduct of Board Members. I think, Chair, we probably have to consider this, given the discussion we had early on around members holding political office. So although we commented on the side, the comment was around again the issue around holding or disclosing members having to disclose past or current participation in political party activities. I think given the discussion that we had early on in relation to section number 11, I think we're probably going to have to align the position we take on this one based on how the discussion was concluded.
Okay, let's proceed to the next then.
Okay, Chair, next section, Chairperson, is under section number 23(1), C for Charlie, Chairperson, where there was a comment, Chairperson, last week that the department consider including a definition of the phrase integrated development. And our comment, Chairperson, on the side is for us to delete this particular subclause or subparagraph by virtue of the fact that this definition, Chairperson, is covered in the Spatial Planning and Land Use Management Act as SPLUMA, Chairperson. Thank you.
Thank you. If there's no hand, we can move.
Thank you, Chair. The next particular comment, Chair, is in the very same section, but not just moving one or two paragraphs down, paragraph number E, where the question is in relation to the content of that section. Our response, Chair, as a department here is that the intention of this provision was to align with sections 84 and 85 of the Municipal Structures Act. Therefore, this particular sub-provision, Chairperson, was inserted to ensure alignment specifically with section 84 between brackets 3 of the Municipal Structures Act. And what you will see below, Chair, is a verbatim quotation of that section, which provides that the minister may by notice in the Government Gazette and after consultation with a cabinet member responsible for the functional area in question, and also after consulting with the MEC, the government in the province, authorize a local municipality to perform a function or power, as mentioned in those subsections here. So it was more to ensure alignment with this particular section, Chair. Thank you.
Thank you. I assume there's nobody opposed. Can we move?
Thank you, Chair. 23.
I see Honorable Smale.
Chair, yes, Chair, just on the wording of the capacity of the municipality, because we're talking about the demarcation process there, and that's now 23(1)(e), where we emphasizes the word, the actual capacity of the municipality. And are we then, I'm just trying to understand, because if we are going to bring in the word capacity of a local municipality, then we have got to have a set of guidelines to determine what would be the capacity of a municipality during this process. And one can argue, if you look at the various grades of municipalities, it's going to become an argument. It's going to become an argument of the strength of the corporate governance sector. I'm just trying to understand, has the capacity to execute that function. So I'm just trying to understand why shouldn't be it, if a municipality hasn't got the capacity in the past, if we're talking about the Municipal Systems Act and Structures Act, a municipality normally approaches a provincial department for assistance or in line. I'm just trying to understand that we might be a minister or a MEC might decide that a municipality hasn't got the capacity, and therefore the following procedures should be done, and therefore there's going to be an argument, or a municipality might litigate against the MEC then on the wording of capacity, and therefore there's going to be a fight. So I'm just trying, if we are going to bring in the word capacity, then we have got to in the form of regulations, we will have to say what the wording of capacity means and define that.
Do you have a problem with what is contained on the right-hand side, which is a comment of the department, where it says this thing is in the Structures Act? In fact, I think when you want to intervene because of capacity, there's a process that gets followed in terms of what is written there.
That's fun, Chair. Okay, if the process is followed according to that, I understand that then.
Okay, let's proceed then.
Thank you, Chair. The next section, Chairperson, is in relation to section number 24, M&O, relevant. So our comment here, Chairperson, is that so the insertion of these provisions, in other words, subparagraph M, subparagraph N for Nelly and O for Oprah. The insertion of these provisions was to reiterate or emphasize the importance of ensuring that policies across the three spheres of government must complement each other rather than contradict, and must be considered during boundary determinations. So it was more included in this particular bill, Chairperson, to just to reiterate the responsibility to ensure that there's alignment in policies when one talks about determination, boundary determinations. Thank you.
Any comments? None. Let's move then.
The next one is section 26. It says here that I think the suggestion last week was that the minister or the MEC must provide motivations whenever they propose redeterminations of municipal boundaries. And the response from the department was that section 26(1)(d) for donkey below already require motivation. So the proposal that the minister or MEC must motivate their request is already addressed below in section 26(1)(d).
Okay,
It should be 2D, not 1D. Sorry, Chair.
could be. Then let's move if there's no hand.
Okay. This section 30, 2. The authority may establish appropriate mechanisms, processes, and procedures to enable members of the public to participate in the demarcation process of the authority. Our response as a department chairperson is that we've noted the comments. However, we propose that the section, now we're saying that in the section itself, our proposal is that there should be a cross-reference in the particular section to section number 17 of the Municipal Systems Act, chairperson, where already these mechanisms are outlined. And what we've done, Chair, is just to confirm in the comment box what the section is saying. It's saying that participation by the local community in the affairs of municipality must take place through A, political structures for participation in the Structures Act, B, mechanisms, processes, and procedures for participation in the municipal governance established in terms of the Act, C, other appropriate mechanisms, processes, and procedures established by the municipality, D, through councillors, etc. So I think, Chair, the suggestion here is in the text itself, we just cross-reference to that section 17 in the Municipal Systems Act, and the drafters will assist us with that.
Okay, can we move then?
Thank you, Chair. The next one, Chair, is section 32(4)(b), where the suggestion was for us to change the reference to 6 months to 9 months, Chair, and this was supported by the department, and the understanding is that legal drafters will make sure that we support this text. Thank you.
Let's move.
Thank you, Chair. Next comment, Chairperson, is around section 38 with regard to the appeals authority. And I think the comment that came through here, Chair, was for us to consider a much more comprehensive or for us to include a much more comprehensive text in the bill itself to outline the establishment process of the section or the appeals authority. Chair, I think, Chair, as a department, Chair, our view is that this approach we took in the current version of the bill, Chair, is consistent with other similar structures that is provided for other legislation. For example, Chair, we did analyze or go through the draft public procurement bill, where there's provision made for the establishment of a public procurement tribunal, Chair. And our reading of that bill, Chair, is that procedurally, Chairperson, a similar approach has been crafted in that bill, Chair. And hence, our view is that how we've done this versus how it's done in other legislation, Chair, there's alignment, Chair. And hence, from where we sit, Chair, as a department, Chair, we are comfortable with how the text is currently crafted, Chairperson. Thank you.
Thank you. If there's no comment, we move.
Thank you, Chairperson. The next section, or next comment, is on section section 47, where I think the comment, Chairperson, here was just for us to make sure that the authority is provided with enough resources to conduct the municipal capacity assessments, Chairperson. So our view, Chair, is that we have no problem with the comment. We support the comment, but we don't think there's any need for us to re-emphasize that particular point in the bill itself, because the authority must make sure that they make available enough resources to enable them to conduct the municipal capacity assessments, Chairperson.
Okay, noted.
Okay.
Can move. Okay.
And the last comment, Chair, from what I can recall, is section 48, where I think there was a suggestion made around draft regulations being processed via Parliament or through Parliament for parliamentary scrutiny, Chairperson. The comment from the department is that this particular aspect is already addressed, Chair, in section 120 between brackets 7 of the Municipal Systems Act, and hence we are of the view that we can just make sure that this part of the bill is aligned to section 120 between brackets 7 of the Municipal Systems Act. Chair, that from what I can recall, Chair, is the last comment that we were required to respond to, Chair. Thank you very much.
Thank you very much. Honorable members, with the approach we adopted to go clause by clause, and I'm sure we were agreeing as we were moving down, where corrections suggested were noted, they were noted. The expectation is that depending on the capacity of the department and our legal services, if they can produce the list, the bill tomorrow with amendments, would be sitting for that. If they say, because I apologize for them, when we started, if they say they may not be able to do it tomorrow, then next week when we must adopt the bill, we'll start with that, looking at all the changes that have been effected. Can that be noted? In other words, we'll inform you as we interact with them beyond this meeting, if that would be possible tomorrow, but the bill would be adopted next week. So if they can't do it tomorrow, then we'll do it next week before we adopt. Can that be accepted? Honorable members?
Yes, Chair. Yes, Chairperson, we accept it.
Honorable Kabanjaba is accepting that. Let's hear after the meeting if the changes that would have been affected would be presented to us tomorrow. If not tomorrow, then on the 14th next week. With that, why should we not close the meeting? In fact, the original legal advice, I thought also I would come to that. The legal advice that we sought, we wanted to clarify a few things that were raised by Honorable Honorable Spies about the public hearings and the process. I'm not sure if with that advice given to us, we are all clear about what was said. They told us in the end, the legal advice was saying, because they are not the ones who were conducting this, all they can give us is cases where this matter has been raised and relative to what we have been doing. But in the end, they said they left it to us. So I don't want us to move out of the meeting, different views about the public hearings. The summary itself, which was given, that we had to involve the public. Then there was a process outlined to do so. Visited all the provinces. I think even in this one of Cape Town, where there was no show, that was repeated. And but like I'm saying, nobody would ever say you have got a perfect process. But we can live with it if there's. But if there's any member who feel that the advice itself is exposing us to something else, and then I think I also don't want to leave that hanging. Honorable Space.
Chairperson, in that regard, I will always just give my opinion. Whether that is accepted or not, I need to raise it and it must be put on record. That Chairperson, actually, if you read through the opinion, the legal department is actually cautioning us. And that's why they leave it to us to decide, because we know what happened. And we truly know that through the process, what happened is a process that we were mostly not really satisfied with. And I have been very explicit about it. And I will state that in terms of the public hearings, I do not think the process was an all-inclusive process. I do not think that everything and every effort was put in to make sure that the broader public understands the content of the bill, as well as being included in it in a way that is understandable to them. And, you know, we can go into the details of where there was no shows or there were very few people. We can go into the resources that was put in by Parliament, and yet there was no desired outcome, or the desired objective was not met. So there's a number of issues that we have to break down. So I will maintain my position, Chairperson, that I do believe that the public participation process could have been done much better in a much more broader and inclusive way than it was done. And that is where I'm at, and that's the stance that we have. And I do think the legal opinion is from the department is cautioning us, putting it specifically out there, the particular cases cited, and therefore we need to make sure. Otherwise, we will just be seen as a committee that wants to get something done, tick the box, and there we go. Yet we know how people raised their dissatisfaction during public hearings. And even those who supported the bill never supported on the basis that they understood it. They did it for the process to go on, but they spoke on other things. That's just my very minimalistic input. Thank you, Chair.
Yes, I wanted you to comment because, like I'm saying, the process itself, that's why we asked for that legal advice. Honorable members, with that, should we, I think Honorable Space has indicated that that's her opinion about the process, and the legal advice is cautioning us. I think we can note that and hope we are proceeding with the process. I don't seem to see any further hand. I can see Honorable Smale is trying to speak.
Yes, Chair, I think at the end of the day, when we do our final recommendations on this report, we have got to bring some of these issues in, regardless of what the adoption or the agreement is around the actionable. But I do think we have got an obligation as the committee to put a strong resolution or a recommendation to Parliament forward. And I think if we don't do it, then we will not be fulfilling our duties in our as set out in the Constitution and within our oversight responsibilities, Chair.
Thank you. With those words, then, honorable members, can we thank you for participating and those who supported us, and declare the meeting officially closed.
Thank
Thank you.
you, Chair.
Thank you, Chair.
You.
Thank you, Chair. Bye-bye.
Bye.